This meeting is being recorded.
Okay, good afternoon, everyone. Thank you, everyone. My name is Leah Kaburu, Secretary, Sports Dispute Tribunal. I'm delighted to be here, taking the big foot of our chair, Senior Counsel, John Ohaga. He requested me to be here. And the session of Know Our Tribunal has been a great session to let our people know who we are, where we are, and what we do. So I'm looking forward to the very interactive session. Thank you.
Thank you very much, Madam Leah, for that introduction. Anne?
Thank you so much. I'm Anne Githinji, Secretary to the Tax Appeals Tribunal, and I'm glad to join us here, creating awareness about the Tax Appeals Tribunal and generally the tribunals.
Thank you very much. Thank members, as you've heard from our three panelists, those are the three tribunals we're going to interact with today. Before we kick off the session, those who have questions, please pose your question on the Q&A, and then I will be able to ask, or on the chat session, then I will be able to ask our panelists so that we can go in order. So as we all know, we actively have 18 tribunals here in Kenya. And we're going to start with Madam Anirita. Please tell us a brief history of the HIV Tribunal.
Thank you, Madam. The history of the HIV and AIDS Tribunal in the year 2001, or could we start when there was the first case of HIV in 1984, and then the government went into panic mode until 1999, when HIV was declared a national disaster. Then in the year 2001, a task force was created by the then AG, Honorable Mozwako, to look into issues around HIV and ways around management, prevention, control of the HIV pandemic. And among the recommendation of that task force was a need to come up with a mechanism or a legislation specifically to safeguard the rights of people living or affected by HIV. So it is this legislation, which is now the HIV and AIDS Prevention and Control Act number 14 of 2006, that now recommended a mechanism again for implementation of that law. That is, they came up with under section 25 of that act, bears provisions to establish a HIV and AIDS tribunal, of course, to safeguard the rights of people living with HIV or the people affected by HIV. You don't have to be HIV positive to come to the tribunal. Even perception alone would be an issue for the tribunal to deal with. So HIV and this tribunal was established or created in the year 2009, of course by the act, but it did not begin functioning until the year 2011, when Emeritus CJ Mutunga saw in the first board members. And under that section 25, where we are established, the tribunal is mandated to adjudicate cases relating to violations of human rights on the basis of one's HIV status or perceived status. Therefore, the tribunal endeavors to safeguard the rights of people affected by HIV in Kenya by addressing barriers to human rights, of course, under the provisions of HAPCA. HAPCA is the HIV and AIDS Prevention and Control Act. Well, the tribunal has powers equivalent to that of a subordinate court, although it is not strictly bound by the Evidence Act, that is the rules of evidence, the tribunal by by the act is clothed with powers to summon witnesses or call for the production of books of records or receive evidence by affidavit or administer interrogatories or may summon expert evidence. And of course, the tribunal got power to award costs of any proceeding before it. Well, before the promulgation of the Constitution of Kenya 2010, we all know the tribunal was operating under and managed under the Ministry of Health. But after the Constitution 2010, the tribunal moved to the judiciary. The provisions of Articles 159(1) and 169(1) of the Constitution of Kenya 2010 provides that all tribunals that do perform quasi-judicial functions, including this tribunal, the HIV tribunal, do move or transit to operate under the judiciary. And around July 2015, we had our budget from the Treasury transferred to the judiciary. So that's how the tribunal moved to the judiciary. I don't know that is all, or I can continue and tell you about members.
No, first we wanted the introduction and the brief history. Thank you for quite an elaborate one.
All right.
Yes, Madam Leah, please tell us a brief history of the Sports Dispute Tribunal and how it has come into action up to date.
Okay, good afternoon, everyone. The Sports Dispute Tribunal, as many of you may know it, is a tribunal that is a creation of Sports Act, and it started its function in 2014 after the enactment of the Act of 2013 that was enacted by the Parliament. The tribunal is among the first tribunals that transited to judiciary, having been the first members who sat in the tribunal were appointed by the judiciary, who are 9 members. The tribunal's mandate is to hear and determine all sports-related matters, matters of appeals from national organization, matters of appeals from sports registrar. The mandate of the tribunal was expanded in 2016 when Anti-Doping Act was enacted by the Parliament, and they were given the mandate to hear and determine doping matters of all the athletes and athlete support personnel. So in a nutshell, the tribunal has been there for the last 8 years, coming to 8 years, with being in the judiciary. That's what I can say about the tribunal. We are housed at NSSF 24th floor. So anybody who wants to visit our offices, they can come. We have we are able to hear all matters sports, and which are civil matters, and the chairman and members are responsible for hearing and determination of the cases that are brought before the tribunal. That's what I would say briefly about the tribunal.
Okay, thank you very much. Thank you very much, Leah. And Gidinji, please, in brief, tell us, give us a brief history of how the Tax Appeal Tribunal came into force.
Okay, thank you so much, Terasia. So the Tax Appeal Tribunal is a conglomerate, if I would call it, of various tribunals that used to exist before the Tax Appeals Tribunal Act then came into being. So these matters would be listened to based on the tax type. So you'd have the income tax, local committees that would be based on various jurisdictions. Then we had the VAT tribunal, and we had the Customs and the Excise Appeals Tribunal. So all these then were joined together to form the Tax Appeals Tribunal, so that it is now able to listen to appeals from the commissioner's decisions on tax laws which the commissioner administers and enforces. So the laws which govern, mainly govern the Tax Appeals Tribunal in terms of mandate are primarily the enacting statute, that's the Tax Appeals Tribunal Act. This act is a 2013 act, but it commenced in 2015 in April. So then that is when now the TAT, as we call it, began to become operational. It's also highly supported by the Tax Procedures Act. This act is the one that provides the procedures around tax issues. That is why it comes into heavy use together with the subsidiary legislation. So the Tax Appeals Tribunal should be comprised of between at least 16 to 21 members, including the chairperson. And currently there are 11 members. The Act provides for staggered appointments. So that is why the membership may not have been complete at the moment. And in this composition, it is required for us to have between 5 to 9 advocates. And each within the tribunal, then we have panels that are formed. So each panel should have at least 3 members, with a chair being at least either an advocate or a member of ISPAC, and a clerk assigned to it. So the tribunal's mandate is to listen to commissioners' decisions which the taxpayer is aggrieved against, and we call them appealable decisions. They have a specific flow. I think as Madam Leah had mentioned, it listens to civil matters. So that is how the flow goes. It's an appealable decision, comes to the tribunal on appeal, and then it is determined at that level. So that would then mean that the tribunal does not take in criminal elements. It also does not have the jurisdiction over constitutional matters and judicial review orders. Thank you so much, Teresia.
Thank you very much, Madam Angidinji. I will go back to Madam Anirita and Leah. If you can give us the composition of both your tribunals and what exactly they deal with. Anirita?
You're muted, Anlita.
Sorry, I didn't even realize that. Thank you. The tribunal has 7 members, a chairman who has to have experience of 7 years. That is an advocate of the High Court. We have provision for 2 more advocates of 5 years standing. Then 2 medical practitioners and 2 persons representing special interest group. Our board expired, our board term expired last month, that is May 2022. But before we had Ms. Helena Miss, who is now the chair, Nairobi, LSK Nairobi branch. We had Miss Melissa Ngania, who is also an advocate, that is under Section A of 25. That is under A, we have Miss Helena Missy, then the 2 advocates are Miss Melissa Ngania and Miss Dorothy Gemator as the advocates of the High Court of Kenya. Under C, the 2 medical practitioners, we had Dr. Tusimo Jama and Dr. Mary Ann Donga. Then representing part D, the 2 persons to represent a special interest group were Mr. Abdullahi Dirie and Mr. JT, that is Justice Toroinet Somoire. So that is the composition of our board. Back to you and thank you. Or did
Thank
you
you
ask
very much.
what they did? Did I
Yeah,
answer the
first,
question? Sorry?
yes, yes, please. Yes, please.
Okay, thank you. Thank you.
Thanks, Madam Leah.
Yes, thank you, Teresia. The Sports Disputes Tribunal has 9 members, but currently there are 8 as appointed by judiciary. The chairperson, who shall be a person who is qualified to be appointed as a judge of the High Court. At least 2 members who shall be advocates of High Court with at least 7 years experience, have experience in legal matters relating to sports, or have been involved in sport in any capacity, and at least 2 and not more than 6 other persons who have experience in sports in any capacity for at least 10 years. For now, we have 8 members. Our chair is the senior counsel, John Ohaga. Then we have the deputy, with Elena Shiveka. Then we have a lawyer, Madam Jerry Onyango. Then we have Edmond Gishuru, who is also a lawyer. We have Alan Owini, who is also a lawyer. Then we have Maria Kimani, who is in sports department. Then we have these are the person. Then we have Peter Ochieng, who is on sport. And then we have Gabi Ouko, who is also in areas of sport. So that's how our members are blended. We have the legal minds, and we have those people who are well passionate on areas of sport, or the experts in sports. That's how we are constituted. For now, we are 8, so we are missing one member. The appointment of our members is not staggered because they were all appointed in 2014. So they are now in the second session, then the second term of their duration. That and it's like their term will lapse at the same time because they were all appointed at the same time. But for now, the tribunal is fully constituted, and the members are able to hear matters within the days, 4 days in a week, as the matters are constituted by our chair, Mr. Ohaga. Thank you.
Thank you very much, Leah. Now, I'm posing this question to all the 3 panelists. Will you give us in brief how one approaches your tribunal? We will start with Madam Anerita for the HIV tribunal.
Sorry, Madam, I'm not sure I've had Ms. Givenji giving us the membership of the Tax Appeals Board.
When she was doing the brief introduction, she did.
Oh, all right. Yes. All right. So we are on the matters that we hear? Or
no, the matters that you hear, and how does one approach the tribunal? Like, you see how in court we file pleadings and whatnot. So now we want our members to be aware of how we are supposed to approach your tribunal if we have a dispute concerning that tribunal.
All right. First of all, we are located at Reinsurance Plaza, 12th floor. Earlier on, when the tribunal was under the Ministry of Health, it used to operate in the premises of the NHIF building, 15th floor. But now we have shifted, we have relocated to Reinsurance Plaza, 12th floor. And how you can approach us is you can actually visit us in our offices at the Reinsurance Plaza, 12th floor, and visit our registry for any reporting or filing of a statement of claim. And that is how you come to the tribunal with a statement of claim. However, we serve an indigent part of our community which may not be able actually to draw that statement of claim. So when they visit us, we are able to put that into a statement, not able to put that into a statement of claim, but we are able to allocate them an advocate to a pro bono lawyer to articulate their issues. So we have a service MOU, and I want to thank Madam Namisi for really initiating the service MOUs with the legal aid services provider. And so we have a service MOU with FIDA Kenya, Kituo cha Sheria. We have Next Gen lawyers. We have a service MOU with them. We have service MOUs with individual advocates who take up matters from the tribunal for clients who cannot be able to pay legal fees or articulate their issues, now that we don't charge any fee, bearing the vulnerability of the people that we serve. So with these pro bono lawyers, we are able to the clients are able to prosecute their matters, because now this lawyer do not charge anything. The second way you can approach the tribunal, we have already developed or designed an online complaint form, which if you call us, we can send you a link and you can download the form and put in the details as it's a template. It guides the clients on how to enter the information on that template. And when the template is filled, the client can send it back to us and we can do the necessary. The other way you can approach the tribunal is through the mainstream judiciary, that is the e-filing system. We are now under CTS, and so any lawyer can, or an advocate can be able to file a matter through the e-filing system of the judiciary. The matters we deal with, of course, we know jurisdiction of any court or a tribunal is donated by the Constitution or the legislation or even both. And so under our Act, we have several protective provisions, like there is a provision that requires informed consent before one takes an HIV test on anybody. We have also a provision on pre-test and post-counseling, that anybody who goes for a HIV test needs to have pre-test and after the testing, before even the test results are announced, that person is supposed to also receive some counseling and be told what is the next action should the results turn positive. We have provisions on confidentiality of documents. We also deal, a lot of our matters come from issues of disclosure of one's status, and under that, no person is supposed to disclose one's result to another person without a written consent. Neither should somebody take a HIV test on anyone without them asking you to consent to that test. We also have some discriminatory acts, sorry. The Act prohibits discrimination at workplace, say denial of access to any employment, promotion, or no one should transfer any employee on the basis of their HIV status. We also have another discriminatory act in the Act, and that is discrimination in schools. And in this, I have in mind a recent case where a paralegal called us from Garissa to report some cases of violations of the rights. And then again, when we went there, the people refused due to stigma. There is a lot of stigma in Northeastern, a lot of stigma in Central Kenya. and a lot of stigma even those parts of Meru, Isiolo. And therefore, in that, the Garissa case was about 2 pupils who were expelled from school on the basis of their HIV status. Unfortunately, even after the secretariat going all the way to Garissa to collect that case, the mother did not show up due to stigma. And the reason she gave to the paralegal guy was that she will be victimized. She would be victimized should she report the case to us. Another sad story of stigma was that of a boy in Nyanza, where the boy had his teachers stigmatizing him on the basis of his HIV status. And the saddest bit of that is that his books were not being marked, his homework. The teacher refused to assess his homework and any other work. That was too sad. Then the act of also restrict, no one should restrict one to move freely on travel. And in this, I can remember, even I can hear the late Joe Moruki's voice stating and telling us how it was sad then. And at one point, he had his travel documents confiscated on the basis of his HIV status. And that is how the law now, there was a need to come up with a law to protect the people living with HIV or affected by HIV. So no one should be discriminated on the basis of HIV, their HIV status. No one should deny anyone social amenities or employment or insurance or credit facilities just on the basis of HIV status. And Matthew, before the enactment of this law to safeguard the rights of people living with HIV, there was no insurance company, and I'm very sorry to say this, who were ready to offer some policies to the PLHIV. And so there was that exclusion from credit and insurance facilities due to one status. So this was quite pronounced in the early 2000s. But I am glad sensitization did something, a robust sensitization program, at least made some of the insurance companies open up some of these policies to the PLHIVs. So the act again does not allow anyone to compel anyone to go to undergo a HIV test. I don't know, am I going too far?
No. Thank you. You've just given us what exactly we needed. Thank you very much.
Oh, all right. Thank you.
Yes.
Thank you.
I'll pose the same question to Madam Leah. You can tell us how we can approach the tribunal and exactly on what matters, because we understand sport is so broad.
Yeah, thank you, Teresia, again. It's important to let everyone know that the tribunal is fully operational on CTS and e-filing, and any client who want to file any matter with us, they will do what we call e-filing, and they go to judiciary file, and we are able to process it on our end when we receive it in the CTS. But we are open such that any client, any litigant out there who for one reason or another is not able to do e-filing, we allow them through phone or come into our offices physically. We assist them, we guide them how to go about it so that no person is left out. We also allow clients to send emails, maybe to make their complaints or to make their comments or to ask for guidance on how to go about filing their matters. Essentially, the tribunal has done very well, guided by our chair, leveraging on technology, because all our matters are heard virtually, and all our cases are filed via the e-filing. We have the sports matters, and we have the ADAC matter or doping matters. Doping matter, essentially, the petitioner is the ADAC who files to our tribunal notice to charge. Now we pick up the case from there. The addressees again can file after the case has been heard. The first instance case has been heard, the addressee can lodge an appeal to us. So on doping matters, we have the ADAC lawyers filing the cases to us, and even the addressees can file their appeal if they are not satisfied with the decision. So our sports tribunal becomes a very unique tribunal that on doping matters, we are also the court of first instance, and we are also an appellant court. So the chair constitutes different panels to hear an appeal, and that is only for national and low-level athletes that such appeal cases can be heard by tribunals. So far, so good. Our clients are quite techno-savvy. We have had very few challenges of e-filing, and all our matters are heard virtually. So in terms of leveraging on technology, sports tribunal could be the first tribunal or the first judicial unit that went out in March to start using virtual meetings, and we have done excellently well. So we are doing well, and everything is on virtual. And the matters, as I had indicated, through all sports related matters, be it selection to teams, discrimination in selection, unfair termination of contracts, and all other disputes that are related to clubs, federation, and all those disputes are what the members hear and determine at a sports dispute tribunal as outlined by Sports Act 2013. Thank you.
Thank you, Leah. One question, when you're approaching the sports tribunal, what exactly documentation do people file using? Is it a statement of claim like you have been told about the HIV tribunal, or is it a complaint form? What exactly do we file before the tribunal?
And the sports dispute tribunal being a tribunal that hears appeals from decisions that are made by national sports organization, decisions that are made by sports tribunal. So we have the applications are certificate of agencies, we have petitions, we have claims, and appeals from appeals from those organizations. The people who are aggrieved, the clubs that are aggrieved, they file appeals after exhausting the disciplinary mechanism or the mechanisms that they have within their federations and their clubs. So those are types of appeals that we have, applications that we have.
Thank you very much, Leah. I pose the same question to Madam Anne Gidinji about the Tax Appeal Tribunal.
Thank you so much, Teresia. I think maybe before I proceed, I can make use of a few minutes. And Rita, my counterpart was right. I can see I did not get to list the members who belong to the Tax Appeals Tribunal. So I'll just do it very quickly. We do have our chair, who is Mr. Eric Nyongesa. He's been serving in the previous term and is going on. And then we have Madam Delilah Katso, Mr. Edwin Cheluget, Mr. Robert Mutuma, Mr. Jephthah Njagi, Madam Grace Mokuha, Mr. Rodney Othiambo, Mr. Abraham Kiprotich. We have Madam Cynthia Mayaka, Dr. John Kinyua Wangari, and Madam Habon Farah. So those are our members. And maybe just for those who would be interested to know how membership, how you qualify. Well, when you get qualifications based on the degree, law, it cuts across law, finance, insurance, and related qualifications. These are set out in the Act. Then you do need to support that with the Chapter 6 requirements, as well as experience of 10 years. For our chair, he's one who is otherwise qualified to act, to serve as a judge. So having said that, how do you approach the Tax Appeals Tribunal? So first of all, we can be approached online. Unlike the Sports Tribunal and HIV Tribunal, we recently transited to the judiciary just the other day, but we are actively engaging around being able to be onboarded also into the CTS, so that our clients are able to benefit from completely from the e-filing. But for now, we've come up with the online in terms of communicating through emails. I'll share, if you allow me, as you go on with the discussion, I'll share our physical contacts as well as our emails and lines. So that is how you can reach out to us on the email provided. You can also come visit us. Physically, we are located at Ushuru Pension Towers. This was previously called the Corporate Business Center. It's located along Elgon Road on Upper Hill. It's just next to Radisson Blue, and we are on the first floor. So you're welcome to come and visit us there. So the nature of matters that come to the tribunal are such that the first respondent, the defendant, the one on the other side is KRA, who can be named under KRA or a commissioner, maybe a commissioner of domestic taxes, or investigation and enforcement, or customs, depending on how the matter generated within KRA. So once a taxpayer is aggrieved with that decision, then they can then come and appeal to the tribunal. What would normally have happened behind the scenes is that once the taxpayer is not happy with the decision, they cascade it, or that decision is cascaded within KRA to a different department. They call it the independent review of that objection the taxpayer is objecting to. So that department will listen in, and if after having listened in, they still feel that the decision stands, then they will notify that to the taxpayer. So if the taxpayer then feels they're still not happy, then they can now come and approach the Tax Appeals Tribunal. So they do that by filing a notice. They notify of their intent to appeal. That notice in the Tax Appeals Tribunal Act and the rules that support it have set all that out. I may also just send the links to those acts. So they file that notice within 30 days of having been given a decision by KRA or the commissioner. And then once they have filed the notice, and then they have at least 14 days to then file a memorandum of appeal where they state the grounds on which they are appealing. And then together with that memorandum, they attach a statement of facts. This is where they give their story, what the facts are, what is making them unhappy, and they can attach the evidence that needs to be attached. Together with that, they also do attach the decision, the one which they are not happy about, and the notice of appeal to show that they had given notice of appeal. There's a filing fee. I have had the HIV/AIDS Tribunal, for them there isn't. I wish we'd get to that, but for now there's a filing fee. It's a nominal one though, and a very standard one. So no matter the dispute, the filing fee is 20,000. It's set by law. So then they need to have filed that fee for the matter to be able to progress. So once they've been able to file, they will serve the commissioner or KRA. Then they do so by serving through the legal department. So the legal department, I believe, is based on the 4th floor of the Ushuru Pension Towers. Then they give the service to the legal department. The filing can be done online. or hard copy. When there is a hard copies, there could be a requirement. There is a requirement then to furnish enough copies for the various tribunal members. So ideally, maybe for those who have approached the tribunal, you have seen maybe you've been requested to provide maybe at least 9 copies, so that 2 are left with you and the rest with the tribunal members. Another thing that would be important to note is that even as you approach the tax appeals tribunal, it listens to the matters which are still in dispute. So that therefore means that if during your engagement with KRA, there was tax disputes that were resolved, then you need to have paid or come to an arrangement with KRA about the taxes which are not in dispute. Once you have served the commissioner, KRA, then commissioner is also required within then 30 days to respond with that statement of facts, giving then the story on the side of KRA and evidence that supports their side. And then now the matter will be set for hearing. You can approach the tribunal personally. There's a good percentage of persons who come and represent themselves. So contrary to the feeling that maybe it would be complex, it isn't. You can do so. And like every other tribunal, the idea is to keep it easy to engage and simple to engage. So we do apply the Evidence Act. However, there is that free engagement around the proceedings. So self-representation is there. We also have persons who are represented by lawyers. That's also acceptable. And we do have who we call tax agents. These are persons who have been vetted through the process, and then they are allowed to operate as tax agents to represent their clients. So typically you would find the audit firms or accountants fitting into that space, but more and more, even the lawyers, as long as you're able to fit that criteria, then you can come on board and represent your client. I don't know whether there is anything I may have left out, Teresia, but that is how you approach the tax appeals tribunal, and those are the documents that you require. And I think maybe in ending would be just to emphasize that for us, we are flexible. However, in terms of observing the timelines, these are statutory timelines that have been prescribed. The 30 days we have said, the 14 days, the 30 days, they are prescribed by law. And therefore, going out of the timelines then would mean that you need to approach the tribunal separately with an application to see if you can be allowed to file out of time on reasonable grounds. Thank you, Teresia.
Thank you very much, Anne. Let me take you back to the issue of tax agent before we go to the other panelist. You said even advocates can represent people if they fit that criteria. Will you mind expounding what is that criteria? Sorry, we can't hear you.
Sorry, I muted a bit. Yeah, thank you. So thank you so much. Yes, so we have lawyers who do it. They do it. For the lawyers, the advocates, you need not be a tax agent, just the advocate. But for the tax agents, there are regulations under the Tax Procedures Act that speak to being registered as a tax agent. I think given just a few moments, I can confirm for you what would be required for you to be able to be that tax agent, because they're registered with the commissioner. Just give me 1 minute. I'll be able to tell you.
But for advocates, does it come automatic for them to be tax agents?
No. The criteria would be that you need to be an advocate with a current practicing certificate. However, the commissioner must consider. So it's an application. You need to make an application for it. It's not an automatic. You don't automatically become a tax agent just because you are an advocate. However, you do not necessarily need to be a tax agent if you're an advocate. You get what I mean? So I don't know whether that should be construed to be discriminatory. I don't know, because the advocate gets to represent the client as it were, but maybe somebody from the ISPAC membership who is not an advocate would need to first go through being a tax agent. Yeah. So you have those three avenues. You can either represent yourself, you can either go with an advocate, or you can either go with a tax agent. And for one then to be a tax agent who is representing their client, they can either be an ISPAC member, an advocate, or a tax administrator who has enough experience and has been registered by the commissioner as a tax agent. Yeah, the reason then why an advocate would be interested in pursuing the extra step to become a tax agent is that they're able to do more and beyond. Like they can maybe file the returns for their clients. They can do beyond all that, just going to the tribunal and represent their client on a larger scope. Yeah, so but those are the three avenues of approaching the tribunal.
Thank you. And you had mentioned that there's a filing fee of 20,000 shillings, Kenyan shillings.
Yes.
Which is payable upon when you're filing the appeal. So what of the instance that you've just mentioned, if someone goes beyond the statutory timelines and they need to make an application, does the same constant 20,000 fee apply?
Thank you, Teresia. Yes, it does. So it's a standard fee. It's supposed to cater for all your ventilations before the tribunal. So in that case, hopefully then that would make it fair to the extent that it's certain. So you don't expect to get any other fees arising thereafter. So it's that standard fee, 20,000 shillings. I think as we go on with our discussion, I could also share the payment details for payment of the filing fees for those who may not have that information.
Thank you very much. So from what I'm getting from you is, however, how you approach the tribunal, there's a standard fee of 20,000, which is payable only once.
Yeah, you pay it only once.
Thank you very much, Anne. I will go back to Madam Anirita. You had mentioned when we are approaching the HIV tribunal, one can fill an online complaint form, which is to be downloaded. Where exactly can clients, advocates, or anyone who wants to approach the tribunal and wants to fill in the form, download it from?
Thank you for that question. You can hear me. I don't know if I'm muted.
Yes, we can hear you.
Yeah. Oh, thank you. The online form is in form of a link, which we send to clients should they want to approach us. And it is also available in our website. Yes, and I wanted to say something. I know I alluded to discriminatory acts under our act, that is HIV and AIDS Prevention and Control Act. And I am aware of the High Court decisions declaring that only the High Court has jurisdiction to interpret the Bill of Rights and Articles 23 and of course 165 of the Constitution 2010. One of such cases is a High Court Constitutional Petition number 466 of 2014. That is the Royal Media case and the AG and the HIV Tribunal with the Nation Media Group and Kemri as interested party, and of course the discordant couple. And in this case, this was an appeal. The 466 of 2014 was a case, an appeal of the decision of the tribunal in Act number 004 of 2013, where the claimants came stating that they had their fundamental rights under Articles 28 and 31 of the Constitution violated. So the main question before that court was whether in the absence of the enabling provision, that is under Article 23 2, which provides that Parliament shall enact legislation to give original jurisdiction or appropriate power to the subordinate courts to hear and determine applications or redress on the basis of violations or infringement or threat of a fundamental right or freedom in the Bill of Rights. I am also aware that there is a doctrine of exhaustion where the Supreme Court in petition number 3 of 2016 stated that a party needs to exhaust all processes availed by other statutory dispute resolution organs which are provided by the established law before they approach the High Court by way of a constitutional petition. So in that petition, it was a petition by the Kenya Ports, registered trustees of the Kenya Ports Authority pension scheme and the beneficiaries of the said scheme. And the Supreme Court, by upholding the doctrine, went ahead to remit the matter back to the CEO, that is the Chief Executive Officer of the Retirement Benefits Authority, as was provided for under that act. And we also know that although the Supreme Court has a wide jurisdiction ranging from hearing election disputes to the office of the president, and even like this case was an appeal as of right. Even then, the court is not bound by its own decision, but all other courts are bound by the decision of the Supreme Court. There is nothing that stops a litigant, so to say, to make use of the doctrine of exhaustion, but there is an abundance of caution. If you are able to capture the issues of disclosure and stigma very well, then there is a likelihood that you will be able to address issues around discrimination, because there is a very, very thin line between stigma and discrimination. Yeah, thank you. That's what I wanted to clarify, Madam Teresia. Yes.
Yeah, thank you very much for that. Leah, I have two questions from your presentation. So how much does one pay to approach the sports tribunal, and does one have to be represented by an advocate, or they can come and do self-representation?
Thank you, Tricia, for that question. Before I answer that, I needed to give a little clarification on what is filed. How do clients, litigants approach the sports tribunal? They can put a statement of claim where the claim. A person may institute a claim other than an appeal under the Act by the way of statement of claim signed by the claimant or his advocate, setting out concisely the nature of the claim and the grounds upon which it is based and supported by verifying affidavit. So they can bring a statement of claim, or they can also approach the tribunal through an appeal where they file notice of appeal and an appeal brief which should be signed. They can also approach the tribunal via the certificate of agency, the certificate, through the certificate. Now, our tribunal, just like HIV, we have not been charging, but effective from June 2021, after the gazettement of judiciary fees, it was prudent upon us to start charging minimum fees. Like, for example, if it is a claim, it is just 1,000 shillings. If it is an affidavit, it's dependent verifying affidavit is 500. If it is certificate of agency, it's 100. Supporting affidavit is 500. So the fee says you can hear, Madam Teresia, they are quite minimal. The very high fees that we charge could be something like reply to appeal 1,500. The highest fee is 1,500. So memorandum of appeal 1,500. So our fees are minimal, and we make sure that the clients are heard when they have filed appropriately. We make sure that the matters are heard as fast as possible, so that the decision can be made fast. So our fees are as they are gazetted by judiciary, and they are not they are just minimal fees.
When you mean gazetted by the judiciary, does that mean it's something that you can get out there?
Yeah, the gazetted fees, they were gazetted in December 2020, and all the judicial units that were not implementing fees then, and their statutes have not curtailed them to implement, we were to implement the judicial gazetted fees. So we took it upon ourselves to start implementing the fees effective June 2021. Before then, from 2014 to June 2021, tribunal services were free, but effective from June 2021, we started implementing the judiciary gazetted court fees. Yeah, they are gazetted in a gazette notice.
Thank you very much. And does one has to approach the tribunal using an advocate, or they can do self-representation?
Oh, that's a good question, Madam Teresia. Tribunals, as most of you would know, they were brought about so that the justice can be, a normal Kenyan, a layman, what they call the layman, can approach the tribunal and access justice. So a person can just come to the tribunal to represent themselves in person, or those who can afford, their matters can be represented by an advocate of the High Court. So the tribunal is open on either way, depending on the affordability of the litigant. Yeah, we also, Madam Teresia, we also in trying to assist our indigent litigants, we have signed in a memorandum with Kituo cha Sheria, where especially our advocates who come from very humble background, we offer, we extend a hand of help by giving them pro bono lawyers who represent them in their cases. So we have gone out there to make sure that our indigent litigants are represented by partnering with Kituo cha Sheria and other well-wishing advocates who have offered their services free. That we have extended that to our advocates, and they really feel supported because they don't have to pay a penny for representation. Thank you.
Thank you very much for that. A question to Anne. Have you gotten into any MOU with any state organization or NGOs to help your litigants to be able to be represented by advocates pro bono?
Teresia, would that be Anne Rita or Anne Gidinji?
Anne Gidinji, you, sorry, because I understand from the HIV Tribunal and the sports, they have gotten into certain MOUs with certain organizations. What about for the Tax Appeal Tribunal?
Yeah. Well, thank you, Teresia. So we don't have those engagements. We don't quite have them. So, however, what it is that we have been actively doing is trying to sensitize and reach out through any fora that is available, through the members, with the chair, with myself, like what we have right now, to kind of bring awareness on the tribunal. But in terms of representation, no, we don't have that. We don't have that.
Thank you very much, Madam Anne. I'm going to pose a question to all the three panelists. I will start with you, Anne, since you're already on your feet. How long does a case take before the tribunal, barring all the extraneous circumstances such as COVID? In a normal circumstances, how long does it take?
By law, it ought to take 90 days if that is what has been stated. If there is no inclusion of ADR and the timelines that go with ADR, but with the ups and downs, I would give it maybe averagely, could be about, can I say about a year? Can I say about a year perhaps? Yes, but it should, let me quote what is actually in the law. It should take 90 days. It should take 90 days. If there is any subsequent extension, then that has to be by voting or resolution and shouldn't exceed 30 days. Once, however, there is also the aspect of ADR, which is a very, maybe at this point I could include it in, is a very vibrant aspect when it comes to this disputes and the dispute resolution in tax areas. ADR has been embraced quite a bit. So ADR also has its timelines. You're given some 90 days to be able to communicate and engage and reach out to one another as parties. So that can also add on to the time as parties are engaging with one another. And that is also encouraged. We do encourage quite a bit of uptake of ADR. Yeah.
Okay, thank you very much. And a follow-up question. Earlier on, we had mentioned about the filing fee of 20,000. Sorry for taking you back. There's a question that has been asked by one of the members, and they are asking, once you file that 20,000 because of the application and you're granted leave not to file your memorandum, do you use the same receipt you used to file the application with and annex it, or you have to pay another 20,000?
No, like I said, the fee is standard, it's 20,000. So what the appellant would then be furnishing the secretariat with is the bank slip. So that is retained and the records are there. They're able to refer to them. Teresa, are you able to hear us? Thank you. Don't know whether we've lost you a little. Yeah, so maybe I don't know. I'm assuming you can hear me. I can't hear Teresa, but I've seen the question in the chat, and yeah. So there's 20,000 you pay at the time of filing. You get the bank slip, and that is what is retained.
Sorry,
we'd lost you just a little bit. I don't know if you can hear me.
Yes, I can. I was posing the same question to Madam Leah on the duration that a matter can take before the sports tribunal.
Thank you, Tricia. Thank you for that question. Just to let our participants know that Sports Dispute Tribunal is assigned a performance management and measurement understanding, what we call PMMU, or performance contract in the mainstream ministry, that we have stipulated the timelines that will take to hear and determine different types of matters. On average, our tribunal dispenses a matter within 3 to 4 months. There are those ones that are dispensed of fast. There are those ones that delay depending on the back and forth of submitting of document and the authorities. There are those ones, there are few that delays when they transit from the normal court hearing to alternative dispute resolution. But on average, most of our matters, within 3 to 4 months, we have dispensed of most of the matters, because as per now, the active matters, 90% or so are for 2022. They're the ones that have just been recently filed. So we have dispensed of most of the matters that are for 2021 and the other years. So in a nutshell, that's what we do, because our tribunal, to hear matters, the chair constitutes panels of 3. So each panel has the timelines that they should take to hear and determine the matter that they have been assigned. So that is what that's on average how long we take, but there are those ones that can extend depending on the complexities of the matter and such like things. Yeah,
Thank you very much.
Yeah.
Thank you. Madam Anirita, how long does a matter take before your tribunal at the HIV tribunal? Madam Anirita, can you hear me?
Yes, I can.
Yes. How long? I'm posing the same question. How long does a matter take before your tribunal, before it's complete, upon it, since its inception of filing to its completion? How long does it take on average?
Sorry, I had already started talking. I didn't know I was muted. Apologies about that. Like the sport dispute tribunal, we have also entered into a performance contract with the judiciary. That is a PMMU. Basically, that is a tool for measuring our performance, and of course, what we have to do, it got what we have to deliver as a tribunal. It has a tool for measuring the performance. It has its indicators, and our matters take between 6 months and 1 year. And I need to say that by the time Helena Mrs. Board was term was expiring in May 2022, they had actually cleared most of the matters. We had only 2 matters pending for the year 2021. You can see how fast that board worked, and I wish to thank all of them for working so hard and raising the tribunal flag high, and their commitment to service to the people. Now we do not have matters. I mean, we don't have not backlog. What is it? Yes, we don't have any backlog. Backlog is a matter which is more than 1 year. We do not have any because all the matters now we have are for 2022, which is a total number of 36. Yes, for applications, the board used to take 14 days. That is 2 weeks. Back to you, Teresia. I hope I've answered your question.
Yes, you have. Thank you very much. Before we proceed to the next question, there's a question that has been asked in the chat it's a disagreement between the Sports Dispute Tribunal and Tax Appeal Tribunal, where one of the advocates is asking, in the circumstances where an athletee has not been able to file tax or has done that tax evasion thing, which is the best tribunal to approach? Is it the Sports Dispute Tribunal or the Tax Appeal Tribunal? Let me start hearing it from Madam Leah.
Yeah, thank you, Teresia. I think Madam Anne Kithenji is very well placed to answer that question, because, you know, if an athlete has issues of tax, definitely that's a tax matter and should be dealt with at Tax Appeals Tribunal. If I'm not wrong, Anne Kithenji.
With your permission, thank you so much, Teresia. And I completely agree with my counterpart, Madam Leah. I think the athlete, just like it would now be like any other taxpayer having a tax dispute. I believe it crystallizes to a tax dispute. So if it is a dispute that has generated that decision, then they make an appeal to the tribunal. If it has a criminal element, then there would probably be an expectation that the commissioner or KRA would be seeking to have them prosecuted criminally. And then at that level, then they would be seeking defense through the criminal system. I believe that should answer the question.
Okay.
You can let us know. Yeah. I don't know whether maybe Teresa would allow me at this point, so I don't interact my counterparts. Just I have shared some of the contact details I was saying. I have put them on the chat. I think you're muted.
Oh, sorry. I'm asking, why file before your tribunal and not any other tribunal or approach court? This is a question I'm asking to all the three panelists. I'll start with you, Anne, because you're already on your feet.
All right, quickly, that one then would be because the law says so. So the law says so, and because the law says so, so it is. Yeah, you can find that in the Tax Appeals Tribunal Act, and I also share the Tax Procedures Act.
But before the implementation of the Tax Act, where were advocates filing such matters?
Oh yeah, so before that is where I had mentioned that there are various other tribunals. So it would depend on the tax type you are handling. If you're having an issue with VAT, then you'd ventilate it before the VAT tribunal, if it was customs and so on and so forth. So I think that maybe that was also a step to be able to create some access to justice and fairness and all, because simplicity by bringing it together. So that is what they would do. They would go to those various, whether you are doing it as a taxpayer yourself or through your representative or the lawyer.
Thank you very much, Madam Anne. Madam Anerita?
Thank you. You can hear me?
Yes, we can.
Thank you. The reason why is, well, when the Constitution was being developed, I think the people of Kenya thought it would be good to come up with specialized courts to deal with the specialized issues. And that's why now, right here, we have the sports, we have the tax, we have the tribunal. But more importantly is the composition of the board to sit and hear and determine matters on those specialized courts. Why? Because when you look at the tribunal, the HIV tribunal specifically, it has lawyers, and it has doctors, and it has people who have knowledge on HIV field, which means unlike the main courts, the mainstream judiciary, where a court is run by lawyers only, in a tribunal such as the HIV tribunal, the composition of the membership is such that membership is able to dive into issues of specialty, and especially when we come to medical terms in HIV, a lawyer may not really comprehend issues of HIV. We need a doctor there to say, you know, this is how it is. And the same doctor is probably not able to dive into issues of the law. And so the lawyer also complements the doctor. Other people of from the field of HIV, the doctor may know a bit of HIV, but that does not mean the doctor is specialized. And the lawyer may not, of course, know much about the HIV. They may know generally, but the deepest or the issues brought before the tribunal on HIV may yet be stigma, discrimination, may yet be the the psychology of it and all that. Then that composition of the membership is able to deal with issues conclusively. So I would say it's a specialized court with experts' knowledge to deal with issues before it. Then again, there is a doctrine of exhaustion, like the case of the Supreme Court petition number 3 of 2016, which I earlier alluded to, where the court says if there is any other law or any other process provided by the law, before you go to the main court, maybe exhaust the processes provided by the law before you go to the main stream court. Thank you, Madam Teresia. I hope I've answered you.
Yes, you have. Thank you very much. I'll pose the same question to Madam Leah.
Thank you, Tricia, and Lisa has quite exhausted on the same. Sports Tribunal, as established by Sports Act 2013, gave the sports fraternity a platform to bring their matters. As again, Anita has rightly said that the constitution of members is blended, those who are technically in the areas of sport and the legal minds, and even the advocates of the High Court that are in the tribunal, they have interest, or they are people who are very great interest in sport, even when they are being appointed by the judiciary. That is one component that the judiciary check on, whether they have a bias of sports, so they understand the game. So why should a person come to sports dispute tribunal? Why the Kenyan people should approach the tribunal is simply because, as our Chief Justice has rightly put the vision of STAJ, social transformation through access to justice, tribunals become one of the doorway to accessing justice, where it is simple, it is cost effective, and the decisions are expeditiously delivered. You know, when you come to the tribunal, like when you come before the senior counsel, John Ohaga, there is flexibility of presentation. Those legal as formal court proceedings are relaxed, and any person, litigant, the layman, can approach the tribunal at whatever relaxed, without having to have low background to have his matter heard and determined. So tribunals are very key in offering the alternative, the alternative doorway to justice. So I believe that the tribunals will be the big thing where most people will bring their cases, because the time that it takes to resolve a matter, and the cost, again, we don't have the long back and forth and the delays. So that again, so the Sports Act was very key to bringing the tribunal that has unlocked a lot of talents, a lot of wealth, a lot of disputes that had clogged in the sports fraternity. Wanting to make the participants know, if you want to appeal any decision that has been made in this tribunal, sports dispute tribunal, your point of call will be Court of Arbitration for Sport, and that is in Switzerland. So a sports tribunal then becomes very key, because that is your first point of call, and we have to do what that the members have to do what they can to make sure that the sports is done out there. That's why in most of our cases we transit from normal hearings to ADR, because at the end of the day, the warring, let me not call them the warring, the people with disputes must agree, because the game must continue. So it is important for sportsmen and women to know that Sports Tribunal is here to hear your case, to unlock your talents, to unlock your finances, to unlock your potential, because from here, you can only go to Court of Arbitration for Sports in Switzerland. So I think the Constitution did a great service to us to bring on board the tribunals that are well taken care of in the judiciary. Thank you, Tricia.
Thank you very much, Madam Leah. And I will start with the next question. What sort of opportunities does the Sports Tribunal offer for advocates?
Thank you, Tricia. Sports Tribunal has a lot of opportunities for advocates because the advocates represent the clubs in their matters. They represent the litigants in their matters. They represent they have that platform to bring the cases for the people they represent before the panel, and in that way they will grow in the area of the sports law. So the sports law then becomes the big thing that our advocates of the High Court should leverage on, because it's a new area that people are finding themselves into, the matter, the doping matters, the arbitration. So those are some of the opportunities that the advocates of High Court should take advantage of voting in the areas of sports law, so that they can be able to pick up very high profile, huge capital cases that comes that comes to the tribunal. Yes, I think there are many opportunities, Teresia.
Thank you for highlighting some of them. Ms. Anne Gidingis, what are the opportunities that the tax tribunal offers
Thank you
to
so much.
advocates?
Yeah, okay, thank you so much, Teresia. I think maybe just to resonate with what Leah and Anrita have said, there is a lot of, first of all, in terms of also of just joining as a member and chair, we have those opportunities, and the tenures are not permanent. For example, with the chair, there is a tenure of 5 years. That's not renewable. For members, it's 3 years, a possible 6 years. So we're always looking forward to having the advocates join us. And then there's also the opportunities as a representative of your client, whether you're doing it as an advocate or a tax agent. Well, what we wouldn't be focusing on that in a discussion around the access to justice, but we do note for the tribunal that some of these disputes, the tax disputes, they have a lot of, the tax in issue may be very high. And for those who may be representing the client, maybe that would also be commensurate or relate with what the fee that could result. So that also may be something that they could consider, but also just feeding in outside of the tribunal in just the tax dispute resolution system and mechanism, the opportunities for lawyers. ADR is vibrant. I know at the moment the laws provide for mediation through facilitators appointed from the taxpayers, but it hasn't been operationalized. But that's an area which, if it came to be, would be vibrant. Researching and commenting around these laws is also an area to consider. Tax is also quite specialized, just the same way discussing around medical and legal issues would be specialized in sports. Tax is also a specialized area. And I think maybe that is how tribunals are set out to be able to provide for us to adjudicate on these specialized areas. So as a lawyer, that means that you'd be creating a niche for yourself, and taxpayers can reach out to you. Another thing maybe I would draw away, even more away from the tribunal, would be to introduce the lawyers to these opportunities around advisory. Yeah, you see, because as you're going on to resolve the dispute, there's also issues of how you're advising your client, and they would want somebody who is able to advise them around the tax law. So as a tax tribunal member or chair, as a tax lawyer representative, as a researcher, as a mediator, as an advisory or consultant person, we have these opportunities, and we ask that you'd embrace it. And I think as a last statement would be to debunk the myth that tax is complicated, it's maths and all. I think it's interesting to observe that we've been having more and more tax lawyers coming on board, and we hope that that is going to continue. Thank you, Teresia.
Thank you very much, Anne. I will pose the same question to Madam Anirita, bearing in mind that you told us earlier on that most advocates who represent clients before your tribunal, it's mostly done pro bono. So what opportunities are there for advocates?
Thank you, Madam Teresia. Yes, there are very many opportunities like my colleagues have mentioned. And the first one is the one you just said, Madam Teresia. Giving advocates an opportunity to grow in their profession through taking matters on pro bono basis. We have seen most of these pro bono lawyers are young advocates. They are advocates of between between zero, let me say zero, to advocates of the High Court between 0 and say 5 years. And by the time they leave the tribunal to go maybe practice elsewhere, I believe they are well equipped in terms of their skills, in terms of knowledge, in terms of interaction with our stakeholders. We have another big opportunity on the space of the stakeholders and partners. This is a HIV and AIDS tribunal, and we partner with our HIV response partners, and it's a wide stakeholder engagement forum. And you'll meet so many people that you interact with as a lawyer, and you can grow and learn from them. The other opportunity is the training. As I've just told you, we have a vast stakeholder and partners supporting the tribunal. We run some of the programs like legal aid clinics. Apart from that, we train our pro bono lawyers because HIV, we found it's a bit complicated. And of course, approaching the HIV tribunal was at the beginning through the board assessment that they needed some training so that they are able to represent the clients well. So we offer such opportunities of training the pro bono lawyers, of course, with the support of the HIV response partners of the tribunal. We also offer, there are some forums which come by virtue of the tribunal being operating in the space of HIV. We have such forums that we are invited to. One of the forums is the National Technical Working Group on TB, HIV, and malaria. And the tribunal is a member of that TWG, which is convened by NAC under the Ministry of Health. That is a ground to grow. Like I know some of our CUZ leaders and the members who are members of TWGs. So it's a forum that you can grow and learn more. Of course, we have other opportunities like the ADR, like my colleagues have mentioned, that you can actually learn to mediate even in HIV matters. And although we have not enrolled or gotten into the system of court annex mediation, the judiciary for a long time now has run the court annex mediation, and we are hoping to get a way to get into that program. So there are very many opportunities. The opportunity also to serve in the board, like now that our members' term expired, we do not have board members in place. We are waiting for reappointment or appointment of a new board. And so those are some of the opportunities. Yeah, the members who are appointed serve for 3 years, and it's renewable for another term. So yeah, those are some of the opportunities, Madam Teresia. I hope I've answered you.
Yes, you have. Yes, you have. Thank you very much. Before we come to our conclusion, we have a question posed to Madam Anne Githinji of the Tax Appeal Tribunal, and it's relating to non-resident athletes. So the question is asking if a non-resident athlete, after winning and earning an award, and then after taxation of the income earned through the participation of the sporting event, are they also supposed to pay and file in the tax returns in Kenya?
Thank you, Teresia. I think that's a question that may not be within the tribunal. However, just to answer, no, they are not. So what would happen is that the person who has paid them is required to have withheld the tax. That person is the one who is then going to account for that tax, remit the tax. And because this is non-resident, that tax is going to be final. Yeah. So if maybe what we are trying to say is that if maybe the athlete was a resident person, then there would be a tax withheld by the person who is paying, and then at the end of the year when they're accounting, they'll be required to top up. But for this non-resident, the person who is paying is just going to withhold a certain figure, 20%, and then it's going to be remitted. They take responsibility for remitting, and that is done. So no, there are no tax returns.
Thank you very much for that. A subsequent question. It seems like most practitioners in the Tax Appeal Tribunal are auditors and other representatives, or whom you refer to as tax agents. What measures can us advocates take to increase our presence and practice in the tribunal? What is the advice you will give us so that we can increase our presence there?
Thank you. Thank you so much. I think that's a very welcome question. It's a very welcome question. And I think the first response I would say is just come and make the presentation. I will, as I said, I can share some of the laws which we have, but I have found the commendable thing about lawyers, about advocates in our profession is the willingness to be able to go out there and look into the law, seek to interpret it. And tax law, like every other law, is just like that. So having an interest in the tax laws, for example, seeking to interpret, practicing, taking some briefs here and there to learn on the job. Probably you could work with somebody on the side as you watch what they're doing, but I don't think outside of actually coming to the tribunal and presenting a case, there could be hopes of growth. So just come and keep the practice. Another thing then would be to have an interest in the dynamism of tax law. There's a lot of changes that happen within tax laws. Being interested to follow up and see when there are changes and keep up with them. But ultimately, it boils down to, I believe, passion and interest in the area, and a lot of practice, and we get there. But there are no glass ceilings. It is open, and so you can come and join. When it comes to maybe building up your knowledge and your capacity, you can also consider if you wish to do a bit of training around tax, if you wish. There are schools that offer that kind of training. I do know some. I can list one that I know offers that kind of training for those who would be interested. Maybe you might want to go back and do a bit around that. But by and large, passion, interest, and practice, and you'll be good to go.
Thank you very much. You've mentioned about training. That is an area that I'm sure most of us here are interested. You can share the information of some of the institutions that offer such training so that advocates can be able to participate and be seen to participate in the tribunal. Last question for Madam Leah and Anerita. Both of you have mentioned that you have MOUs, MOUs with certain organizations to enable your clients litigants to be represented by advocates pro bono. Which are these MOUs where advocates can go and sign up? And let me start with Anerita.
Thank you, Madam Tracia. Am I mute? No. You can hear me?
I can hear you, yes.
Oh, thank you, thank you. The MOUs are in our offices. Even if you are an individual advocate, you have to visit our registry so that by the time we are giving you the number of files or the number of matters to handle, you can sign somewhere. And even as you sign somewhere, you also sign the MOU. But the initiation of developing an MOU with FIDA and Kito, because that is what we started with, was by the fact that matters took too long to be prosecuted. Like matters were not moving. There were mentions after mentions after mentions, and every time we could call the client is like, I'm not able to articulate my issues on my own. I need some assistance. I remember we started off with Kellen. Kellen also, after the tribunal moved to the judiciary, I don't know what happened, they pulled out, or maybe they were more on probably health issues. I'm not very sure why they pulled out, and therefore it was very important that we look for some other lawyers who could assist us or assist our clients so that the matters could move. So we have those MOUs with Kituo cha Sheria, FIDA Kenya, Next Gen lawyers, which was initiated by Madam Katindi or Advocate Katindi Melba. And they have done a good job in prosecuting those matters. And we also have individual advocates, and those advocates are also supposed to sign the MOU with us should they take matters. So if there are any lawyers, individual lawyers, who would wish to come and pick some of our matters on pro bono basis, you are welcome. You come to our registry and we will allocate you matters. And as we allocate you matters, you will sign the MOU with us. The beauty of signing the MOU with us is, should there be some of the opportunities that I have earlier alluded to, then we could consider you to some of those opportunities. Especially the training of lawyers, engagement with the HIV response partners, or with any other forum that we are called upon by our partners to participate. Thank you, Madam Teresia.
Yeah, thank you for that elaborate. Madam Leah?
Thank you, Teresia, for that question. As I indicated earlier, we have signed an MOU with the Kituo cha Sheria. So advocates who want to know more about sports can liaise with Kituo to sign in. They can come to Sports Dispute Tribunal, 24th floor, where we'll also be able to assist them so that they can join us in the pool of advocates who are offering their pro bono services to our clients. So the door is open for those advocates who want to venture into the world of sports. It's a huge market out there, and there are a lot of opportunities. As Anne Kidinji talked about, you can work towards becoming a member. You can take the role of arbitration, mediation, which is a very key component in sports. Mediation is a big thing in sports, in sport fraternity. So any lawyer who is interested, the doors are open. Come, we'll be able to let you know how you join us. Thank you.
Thank you very much. And I'll start with you, Leah, the last question. Since it seems like we have answered all the questions that were posed by the members, will you please give us your location and address of your tribunal so that now, as you've mentioned, so that advocates can come and grab the opportunities you have for us?
Thank you, Madam Teresia. I think I've already posted the physical address in the chat box. If you can check, you'll see Sports Dispute Tribunal. We are at NSSF building. NSSF is at Community community, most of you know community. NSSF Block A, we have 3 blocks in NSSF. So we are in Block A, 24th floor. When you take the lift to 24th floor, where you are light on your left, you will be able to see Sports Dispute Tribunal. All of you, you are welcome. When you have time, just pop in, come and know what we do. Send those who have matters of sports. We are ready, willing, and available to hear and to unlock the great potential that there is out there on sports matters. Thank you.
Thank you very much, Madam Blair. Madam Anirita Murungi, please share with us your location and address so that you can come and grab those opportunities you have for us.
Thank you. Thank you. We are located at Reinsurance Plaza, 12th floor. And we have contacts, we have email addresses, that is hivtr@court.go.ke. We have our social media platforms, Twitter and Instagram. What is the other one called? Facebook, and there is another one I forgot, LinkedIn. So we have those platforms which I will be sharing before we leave. I think I should now click the chat box and start inputting before the time is over. And what else to reach us? Yes, email address. You can come physically to our 12th floor Insurance Plaza. You can email us. You can reach us on Twitter or Facebook, social media platforms. Yes. I'll be putting some of these addresses on the chat box. Thank you, Madam Tricia.
Thank you very much. So members, you've heard it all from our 3 panelists, and they have quite exhaustively enlightened us on the tribunals, what they do, what they partake in, the opportunities that you can go grab, because especially as we promised at the Nairobi branch, it's all about ensuring our bread and butter is going to be catered for. So we want to thank you very much for taking time to come and empower us with such knowledge about your respective tribunals. And members, please, you can check from the channels, the Sports Dispute Tribunal, the Tax Appeal Tribunal, and the HIV Tribunal together with the email address in case you want to contact them. With no further ado, because there's no any other question, I want to thank all the members for coming, the panelists, Nairobi branch, for enabling us to have this Know Your Tribunal event. I also want to take this opportunity to thank you, our other 2 council members that were on board. That is Victor Mulindi. You can, Victor.
Hi, everyone. Thank you, Tess, for the good moderation, and also to the 3 wonderful ladies in their various tribunals. I think my knowledge has been improved in what these tribunals, the good work they're doing, and that they are powered by ladies. I think that's really important. So I look forward to working with you, especially with Anne at the Tax Tribunal, as I'll be convening the Tax Dispute Tribunal liaison committee. So I look forward to working with you. Thank you so much for the help. I really appreciate it.
Thank you very much, Victor, for creating time and joining us. We were also joined by another council member, Josephine Oyombe. Josephine. It's okay. It seems like she did log out before we could finish. Well, we send our regards to all the members. We wish you a lovely evening as you log out. Please check all the details that you need for the respective tribunals. I hope the input and the presentation by our panelists was quite educative to all of us, because personally, I have learned immense. And I will be going to visit all the respective tribunals to see what opportunities lie forth for me and my law firm. And I will encourage members to do the same. And members, have a lovely afternoon. As for the panelists, I will request you to remain for around 5 minutes. Thank you. Thank you very much, Mui Sharon. And I hope you will join us in the next Know Your Tribunal session, because we'll do them almost every month.
Thank you.
Yeah, we can, please, I will still request the panelists to remain for like 5 minutes.
All right.
You're welcome, Sarah, Anya, and I hope you will join us for the next session of the Know Your Tribunal, and also encourage your other peers and classmates, colleagues to join so that they'll be able to be educated as you have. Thank you. My